Welcome to Rajya Sabha TV. You're watching a special show on Parliamentary Standing Committee. I'm Amritan Shurai. In this show, we bring to you in-depth coverage of reports of the Standing Committee on the functioning of ministries and its departments. Today, we bring to you a report of the Ministry of Human Resources and Development on National Accreditation Regulatory Authority Bill. The Standing Committee on MHRD feels that the 5-member accreditation watchdog proposed in the bill is inadequate and has recommended several changes in it.
As per the present practice, accreditation is voluntary for educational institutions. This has resulted in less than a fifth of the country's colleges and less than a third of its universities with accreditation. The National Accreditation Regulatory Authority Bill was introduced in 2010 and seeks to integrate India with the global quality assurance system for higher education. The bill seeks to create and regulate the functioning of multiple accreditation agencies. The bill seeks to create an umbrella body, National Accreditation Regulatory Authority (NARA), that will regulate the functioning of multiple accreditation agencies in the country. The body will be expected to raise the standards of academic institutions in the country. While accepting the need for mandatory accreditation, the Standing Committee has said an institution should be made eligible for assessment only after 2 batches of students have passed out of the institution. It also suggested that if an institution is found not eligible for accreditation for justifiable reasons, it should be given another opportunity to get itself assessed. The committee has recommended a period of 2 to 3 year validity for agencies that will be empowered to provide accreditation.
That unless the first batch is passed out, you can't really process how they are dealing with it. So just on the basis of the initial investment in infrastructure, you cannot draw conclusions about the standard which they are maintaining.
In a large number of the countries, there is a notion called pre-accreditation. So in those nations, the accrediting agency also undertake the work of accrediting the programs right from 1 or 2 years from the inception of the program, whether it completes out 2 years after the first graduation or not.
Institution, when it is set up, it takes a certain amount of time to establish itself, consolidate the processes of teaching, learning within the institution, and therefore it takes time to be a candidate to be assessed for quality.
The proposed law seeks to establish a National Accreditation Regulatory Authority (NARA), which will register independent accreditation agencies and lay down norms for assessing institutions. The bill proposes a 5-member panel including a chairperson. The committee says because of the varied functions of the committee is expected to perform, its strength needs to be increased to represent various stakeholders. The members of NARA are to be appointed by a selection committee. The Standing Committee has suggested that the selection committee should be led by a person of academic eminence in the fields of social science, science or technology.
हर फील्ड के स्पेशलिस्ट उसमें कमेटी में फर्दर और नीचे आकर के उसकी व्यवस्था बनाई गई है, लेकिन जो एडमिनिस्ट्रेटिव बॉडी होनी चाहिए, जो कंट्रोलिंग बॉडी होनी चाहिए, उसकी संख्या तो निश्चित तौर पे हमें कहीं ना कहीं निर्धारित करनी ही पड़ेगी.
There is a requirement that all disciplines or all professions must be represented. If NARA has just a regulatory authority, then few members can also work.
You should have a judicious mix of members who represent most of the disciplines, not making it a too large body to be really become effective, and it should have good mix of people from the academics and also from the industry, because ultimately the student has to make a meaningful entry into a job market.
The committee has recommended specific provisions for medical institutions to be included in the bill. This would avoid any overlapping or conflict of interest with other institutions that are to be set up under the Ministry of Health and Family Welfare.
HRD ministry doesn't control agriculture education, medical education. It is the department-wise thinking. So physical education and
टेक्निकल एजुकेशन हो चाहे वो मेडिकल एजुकेशन हो, इसमें तमाम विसंगतियां और तमाम स्कैंडल्स आते रहे हैं, प्रकाश में आते रहे हैं, और उनकी दृष्टिगत रखते हुए इस बात की आवश्यकता महसूस की गई कि एक एग्रेडेशन कमेटी होनी चाहिए.
The standing committee has also recommended that agriculture be brought under the ambit of NARA. The bill has excluded institutions providing agricultural education on the grounds that it is a state subject. However, the committee said such institutions should be included in accordance with national interest as mentioned in the Constitution. The Standing Committee report on NARA Bill was upset with the fact that the HRD ministry did not properly consult with the major stakeholders of higher education. Not only this, it also expressed its concerns over non-consultation with the state government. With camera person Shivi Sudarsan, Subina Roy, Rajya Sabha TV.
The Standing Committee feels that a separate set of techniques should be evolved for assessing medical institutions. To tell us more on the issue, I am joined by my colleague Subina Roy. Subina, what does the committee feel about this?
Yes, Amritanshu, there is a separate legislation for medical educations in India called the National Commission for Human Resources for Health Bill, the NCHRC bill. This bill talks about setting up of a National Evaluation and Assessment Council which will set standards for medical institutions in India. This was the reason why the committee said that there should be different provisions for the NARA bill regarding the medical institutions so that there is no overlapping and conflict of interest between the NARA and the NCHRC bill.
We spoke to Mr. N.K. Singh, member Standing Committee on MHRD, and began by asking him the assessing before accreditation.
So the Standing Committee was also of the view that accreditation should happen only after 2 batches of students have passed out. So sir, what is your comment on it?
My comment is, why deny the students who have really passed out in the first 2 batches the advantages of the accreditation, which will really mean that the students will be left in some doubt on whether the institution meets the necessary benchmark or not. So my view would be that accreditation should be a prior condition and not really after 2 batches, because it would not be fair to deny.
As you were talking about the private entities being enrolled under NARA bill, but the committee said that we are not of the view that private trusts and societies should be included. So could you elaborate on this point?
Primarily, the regulatory body is to ensure level playing field between public and private entities. So if you completely eliminate the private entities, then there is no need. And if the accreditation agencies are also completely government dominated, if not government owned, there is no need to have an authority of this kind sitting over another governmental body and then having an appellate body.
There were questions about the constitution validity of this particular bill. So how do you assess this?
Personally, I think that the issue of constitutional validity of the bill has been gone into, that the central government has the power to legislate. The important thing is to ensure that the role of the state government is not completely diluted, and that in the representation both of the selection committee and in the constitution of the authority, state governments are assigned.
All right, sir. The NARA bill also has a provision that the board should consist of a chairperson and 4 members. But the committee was of the view that the committee members should be expanded so that there is proper representation from all the fields. So how do you see it?
In my view, as being a member of that committee, I had strongly also argued that for a large country of this kind, looking at the complexity of disciplines, we need to have really a larger number of membership to really give representation and presence to a wider range of disciplines, which I think would be necessary, looking at the diversity of disciplines and pedagogy which is being taught in this country.
Sir, also talking about the medical education in India, we all know that there is already one institution called Medical Council of India. So why bring this premier, like this medical education institutions under the ambit of NARA Bill, sir?
Well, this was an issue which the committee deliberated on, and the committee heard the representatives of the Medical Council and heard the representatives of other medical associations, other bodies. And the government's argument is to have one overarching body, leaving aside only agriculture, which is really a state subject. But the committee, I think, does have subsisting doubts on whether really this bill or this body should become such a dominant overarching body to cover the medical discipline as well. And I think that on that also there is likely to be differences of opinion when the debate takes place in Parliament.
So coming to this agricultural education part, sir, why agriculture institutions have been left out?
Because the argument given by the government is that it is part of the state subject, and that they are really speaking, they are not very sure whether they have the legal right or the constitutional mandate to be able to legislate on agriculture. But I think that a way should be found out where agriculture, which is a very, very important part of our entire economy, the agricultural universities and agricultural research, and should be brought under the ambit of this bill in one form or the other. And I think that some mechanism which has a linkages to ensure that the agricultural universities are not left out in the quality assessment process, that should really, in my view, also is something on which further thought needs to be given.
So the standing committee also thinks that the rules relating to the penalty provisions of anyone who violates the NARA officer. So how do you assess that particular?
In my view, that those need to be somewhat re-looked at, because sometimes you may have an awkward situation where a constitutional head or the governor could be facing penalty proceedings by virtue of the linkage which the governors or chancellors of universities have. And I think that those penalty provisions certainly need to be re-examined and re-looked at from the viewpoint of the existing constitutional provisions which exempt certain category of people from this kind of penalty proceedings.
Sir, the committee also suggested a grievance redressal system for ensuring more transparency in the registration of accreditation agencies. Sir. So how do you see at this particular recommendation?
In my view, that it is a positive recommendation to have a grievance redressal mechanism, because I think that in the process there are bound to be difficulties, particularly in the initial stages. There are bound to be teething problems, and I think there are bound to be ongoing problems. So I think that having a robust grievance redressal mechanism would be a positive step.
It's time for us to head into a break. When we come back, we will tell you what the committee feels about empowering societies and trusts as accreditation agencies. Welcome back. The Standing Committee is opposed to the idea of granting accreditation agency status to societies and trusts. According to the committee, there should be complete transparency before agencies are given such certificates.
The report of the Standing Committee says an accreditation agency under NARA should be a non-profit organization registered under the Companies Act, and it should be controlled by the central or state governments. The committee also suggested that the guidelines of good practice in quality assurance formulated by the International Network for Quality Assurance in Higher Education be used as an additional input along with the eligibility criteria prescribed for agencies to empower accreditation agencies.
That is what we don't want a registration of accreditation to take place basically, because it should be only government agencies. Otherwise, this is not the time when you can go ahead with the privatization effort. And that privatization at this juncture is not feasible, not advisable.
The foremost condition, it's the transparency and credibility. So I personally feel this factor should always be kept in mind, and we should not discriminate on the basis of the private or government agency.
प्राइवेट ट्रस्ट अगर इस तरीके से कर दिए जाएं लोकतंत्र में, और इतना कर दिया जाएगा, तब तो सरकार नाम की और राष्ट्र नाम की कोई चीज रही नहीं जाएगी.
The committee report seeks more transparency while selecting accreditation agencies. It recommends that the agency should have tenure of 5 years, extendable up to 10 years. The committee feels the provision allowing any person aggrieved by the decision of an accreditation agency may appeal to NARA is vague. And in place of it, the government should set up a grievance readdressal mechanism to ensure transparency.
If somebody has a genuine grievance that though I have the full satisfactory infrastructure and so faculties and everything, but committee has not taken note of it, if there is a genuine grouse, it has to be a redressal grievance mechanism in which there cannot be a delay for a decision of more than 90 days.
Assigning a certain level of competency to that organization, I think you should also provide for a mechanism where the institution or their representatives have enough provisions to make an appeal. The finer points of what is the penalty and how much should be the penalty, these are matters of detailing and they can certainly be worked out.
लोकतंत्र में भी उसकी व्यवस्था संविधान में की गई है, लेकिन कुछ मजबूरियां होती हैं लोकतंत्र की, और ये अधिनायकवादता नहीं है, कोई डिक्टेटरशिप नहीं है, इसलिए दंड का प्रावधान उतनी सख्ती से लागू नहीं हो सकता है और लोकतांत्रिक व्यवस्था में कहीं ना कहीं नरम रुख अपनाया जाता है और उसके तहत आप इसको कह सकते हैं कि ये बहुत इम्प्लीमेंटेशन इसका बहुत ही सुदृढ़ तरीके से इसको लागू नहीं किया जा सकता।
The committee felt that penalty provisions relating to obstructing officer of NARA is vague and may be misused. It felt that the accused should be given a chance to clarify his position. It recommended that procedure for enforcing this provision be clearly prescribed through rules. It has suggested that governors of the states should not be held responsible in case of an offence committed by a society, trust or institution.
Only because they are included in the national, they are declared as nationally important schemes, that doesn't make them permanently class 1 universities or the centers.
IITs and IIMs should also opt for the accreditation as it is in their own interest. During the process of accreditation through peer review, they will also come to know that what are the areas where they need more improvement.
निश्चित रूप से ये सोच के ये मान के चलना चाहिए और ये सही भी है कि जहाँ गुणवत्तापरक शिक्षा में कमी हमको नज़र आ रही है उसे हमें और सुदृढ़ तरीके से गुणवत्तापरक बनाना चाहिए और अन्य इंस्टीट्यूशंस को भी उन इंस्टीट्यूशंस के पैरेलल लाके खड़ा करने का जिम्मेवारी भी सरकार की है।
The bill allows the central government to exempt any class of institutions from obtaining accreditation, but the committee seeks to delete the clause or frame specific norms on the basis of which the government can grant exemption. The Standing Committee recommended that specific provisions in the context of medical institutions needs to be included under the NARA Bill, keeping in mind the specialized nature of the subject. With camera person Shivi Sudarshan, Subina Roy, Rajya Sabha TV.
According to the recommendation of the Standing Committee, agricultural education should be part of the regulatory authority as proposed by the government. To tell us more on the issue, I am joined by my colleague Subina Roy. Subina, what does the committee feel about this aspect?
Amritanshu, the committee was disappointed with the fact that the ministry had not included agricultural institutions within the ambit of the NARA Bill. When it questioned the ministry regarding this, the ministry said that agricultural institutions are a state subject and the parliament can only legislate in matters which are of national interest. However, the committee was not satisfied with this argument of the ministry and it suggested that suggestions and measures should be taken to include agricultural institutions within this NARA Bill.
We spoke to Mr. R.P. Sisodia, Joint Secretary in the MHRD, and began by asking him the viability of the overarching regulatory authority.
Sir, what were the suggestions of the ministry about this particular NARA Bill?
No, ministry had formulated the bill and introduced it in the parliament, and then parliament referred it to the standing committee, and standing committee had sent us a questionnaire in which standing committee wanted to know about the specific provisions of the bill. It also had certain queries to ask us as to what is the system prevailing in other countries, and so we replied to the questionnaire of the standing committee in writing, as well as there was a hearing in which our views were heard, and we made a presentation before the committee explaining the salient features of the bill.
Sir, what were the specific suggestions that were given by the ministry?
No, suggestions in the sense that we only clarified to the committee about the queries that they had. Suggestions were not there since the bill was actually formulated by the ministry. So, in turn, the Parliamentary Standing Committee examined the bill and then gave certain recommendations.
What were the amendments?
The main amendments in this particular bill were that number one, the process of assessment was separated from the process of accreditation. The committee had suggested that accreditation should be undertaken only after 6 years of completion of an institute. So we, in order to give the concrete shape to that suggestion, we separated the two processes, and then we also specified that every institution which has completed 6 years of existence would have to undergo accreditation.
Sir, the committee was of the view that agricultural institutions should also be included within the purview of the NARA Bill. So, sir, what was the ministry's viewpoint on this?
No, while ministry was very appreciative of the committee's concern as well as the committee's suggestion that we should bring in agriculture education under the purview of the bill, but our hands were tied because the agriculture education falls in the state list.
Also, the committee took the viewpoint that medical institutions should also be included within the NARA Bill, and there should be specific rules regarding this. So, what was the ministry's viewpoint on it?
No, medical education is a part of the NARA Bill, and medical education would continue to be with the in the purview of the NARA Bill. And when we frame the rules for that particular, because we'll have to frame the rules under the Act. So when we frame the rules, we will take that into account.
So, your concluding remarks on the Standing Committee report?
The Standing Committee report was very positive. It appreciated the concern of the government for infusing some kind of independent quality assurance mechanism in the entire higher education sector, and the committee was appreciative of the fact that this bill will go a long way because it is making it mandatory. So students and parents will have an independent quality assurance mechanism available by which they can take informed decisions about the admissions and all that. So this is this legislation was actually appreciated by the committee.
Sir, coming to the press registration bill, the Standing Committee had recommended that electronic form of books should also be included in the book definition. Sir, so HRD Ministry is concerned with the books division. So what was the ministry's viewpoint on it?
There was a hearing held by the committee, and committee had specifically asked that when this bill was circulated for interministerial consultations, was this suggestion, but then we were candid enough to admit that it was a subsequent sort of a suggestion and a thought. And also while going through chapter 3 and 4, one notices that there is a talk of physical delivery. So, state governments are the competent authorities wherein the book should be delivered. So, committee, while examining this entire issue, had also taken into account the fact that there is a physical element of delivery involved, which may not be possible in case of electronic versions. But then the committee has recommended in its report that the department should examine the suggestions of the ministry and then make necessary changes. So to that extent, I think our concern has been taken care of.
We are now approaching the end of the show, but before we conclude, let me leave you with the concluding reaction of Mr. N.K. Singh, Member Standing Committee, MHRD.
Our higher educational institutions need to benchmark themselves with the best international practices, with the best international benchmark. Regrettably, India does not even have one institution in the top 50 or top 100, and I think that we should aim towards that, enacting a legislation in haste, as some of the education and HRD ministries' past legislation show has not served the country well.
Thank you for watching Standing Committee. We'll be back with a new episode and a new issue. Keep watching Rajya Sabha TV.